This is a sound grab from Michael Chesterman. I was a full-time commissioner between 1983 and 1987, and then spent another 5 years or thereabouts as a part-time commissioner, all of which was highly enjoyable and really interesting. I don't see myself as possessing the gift of the grab, but I'll do my best to say something about the two questions that the President has asked us to comment on. I think of my time there as a time when a major achievement by the Commission was the completion of a very large number of reports, many of which were very substantial ones, particularly during the latter part of my period there. Probably the most broad-ranging and intellectually challenging and extremely interesting report during that period was Aboriginal Customary Law in 1986, the extraordinary investigation of all sorts of aspects of Aboriginal life and law, and indeed whitefellow law that went on to produce that report, was quite unparalleled in my experience of any time in law reform. At a more down-to-earth level, there were the two evidence reports of 1985 and 87, and the group proceedings report, with then a reference called Class Actions, in 1988. You could say that the first of these subject matters, the reports on evidence, has been meat and drink for litigation lawyers ever since implementation occurred in the Commonwealth and indeed New South Wales. And the second of them, Class Actions, has been meat and drink for a very select group of litigation firms ever since it came on board by federal court and legislation later implemented elsewhere as well. If I was to comment on an achievement of a very different sort during that period, I'd mention the Domestic Violence in the Australian Capital Territory report of 1986. The achievement there was to manage to have it tabled very shortly before a shocking and painful domestic violence incident within the Territory, the result of which was to prompt the Attorney General to say to his advisers, "What can I be seen to do about this?" Their answer was, "There's an ALRC report with draft legislation," to which he said with some relief, "That's great, let's have it enacted." And sure enough, it must have been one of the shortest implementation times that the Commission has come across. A substantial achievement of timing, you might call that. To extent that leads me to the second topic that we're asked to comment on, which is challenges facing law reform now. Implementation has always been a problem for any law reform commission in this country. I know the ALRC's record, particularly in recent years, has been very, very good, but one has to feel that keeping the eye of Prime Ministers and Ministers on the sort of reports that the ALRC produces with their very serious and weighty subject matter must surely have become more difficult in recent years, when the attention, courtesy not of the media in particular, has so much been on more high-profile topics which often have a good deal less content to them, but are more inclined to excite the media to give them a great deal of coverage. And side by side with that, there has to be a substantial challenge in continuing to persuade governments that law reform reports dealing with the particular type of topic that they do, substantial, political only up to a point, and requiring significant research and consideration, it may not be going to come easier for the sort of reasons that I've already mentioned in relation to implementation. But I've no doubt whatsoever that the ALRC, coming up now to its 40th birthday, midlife crisis time, you might say, but I think there's been enough crises along the way to make us feel that that isn't necessarily a crisis of a particular sort now. It has been a great achievement on the Commission's part. I wish it very well for the next 40 years and beyond, and thank you very much for this opportunity to contribute to the 40th anniversary celebration.